All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger here. Just playing a little, I'll turn my Angry Birds off here, Shane, okay? 540-0580. If you have a legal question, we could use your help. I want you guys to help me identify a picture I just put up on Facebook. You're going to have to take a look at it and tell me what the green leafy substance is. And we're going to have a contest to see who can identify it. I want a little more detail than the exact plant that it is, if you can do that. So anyhow, go to Facebook. You can see the picture. I'm not going to tell you where it was taken. You can do your own math on that, but go to Facebook and take a look at the picture. And if you got a theory about it, I want you to call in 540-0580, and we'll talk about it. Well, if you have a legal question, call in 540-0580. Whatever you guys want to talk about, whatever the legal topic of the day is for you. If you want to talk about a divorce, a custody case, a child support case, a landlord-tenant matter, an employment matter, a personal injury matter, some kind of fight with the boss, or were you laid off and trying to figure out if you were discriminated against, whatever you want to talk about. I was on Durgan yesterday, and we were talking about police officers filing tickets on information received. And people were surprised to learn, because it apparently is true in other states, only a police officer can give you a traffic ticket. In Pennsylvania, the police officer has to write it, but anybody could report it. So I could call the police and say, I saw Bob Durgan rolling down the road at 110 miles an hour, and the police officer could write up the ticket. I would, of course, have to come and testify, because the officer can't testify to hearsay, but you can get a ticket on information received. And again, a lot of people are surprised with it. That comes up a lot with driving under suspensions as well, where somebody says, I saw somebody driving under suspension. Pretty serious offense these days. 540-0580, Carl Rominger answering your legal questions. Tom, you're on the air.
Hi, Carl. I have a question about child support.
Yeah.
When the child turns 18, do you have to petition the courts to end child support, or does it just end? Okay,
here's the answer. Theoretically, somebody's going to catch it, and it should end at some point, right? But my experience is there's no automatic way that gets caught, but by a review, by a mechanical review by the hearing officer who periodically looks at the file. So what I tell people to do is, as soon as your child turns 18 and is out of high school, you want to be sending, well, I mean, it depends on how you feel about the child support payment. I guess if you're happy paying it, or you're the person receiving it, you're probably not going to say anything. But if you're the guy or gal paying it, you should call domestic relations, or even just send them a letter that says, hey, in 2 weeks, this kid's not going to be eligible for support anymore.
Okay. Super.
All right.
Good man, Charlie Brown.
All right. Let me know if there's anything else we can do to help you.
I appreciate it. Thank you.
All right.
Bye.
540-0580. Matt, you're on the air.
Hello?
Yeah.
Hey, I had a question. I'm an auto mechanic, and we have a piece of equipment there for tire changing, and it had a malfunction the other day and smashed my hand. And the company that sold us the machine, they had a rep come in, and they're going to request me either go to a doctor or sign off saying, I guess I won't sue them. I didn't know what your opinion on what I should do.
I wouldn't sign anything at this point. First of all, against your employer, you have workers' compensation. And I literally say this. It doesn't matter if you stick your own hand in the machine or it gets sucked in by accident or what. You at least have workers' compensation, which will guarantee to pay all your medicals plus lost wages, okay? So
I've been working. I'm just dealing with some pain. I
right.
mean, at this point, it's...
Well, listen, let me come back to this. On the pain and suffering aspect of things, workers' comp doesn't cover that at all, but a third-party tortfeasor lawsuit would. And that would be a lawsuit against the manufacturer of the machine. So while you can't sue your employer, you can sue for products liability. And I did a case like that one time involving a defective machine, and we were quite successful. So long and short of it is you probably don't want to just give up any legal rights because you don't know where this is going to go. You have up to 2 years to bring your lawsuit.
Should I go see a doctor soon and then figure out go from there? Or?
I would go see my own doctor and let them advise me. If the doc says, hey, this is probably not a big deal, you'll be fine in 6 weeks, and you are fine in 6 weeks, then who cares? Okay. On the other hand, if the doc says, hey, this could really be bad, or the other thing you can get is reflex dystrophy syndrome, where you hurt a nerve and you don't realize it, but over time you'll get some degenerative disease in that limb or hand. So there's a lot of things to be thinking about, and that's why the law gives you 2 years before you have to bring your lawsuit. So signing off now is just crazy, particularly because your meds would be paid by workers' comp, so it's not even like you need money to pay the medical bills.
Right.
You got me?
Got you.
And always happy to talk to you about it after the air as well. All right? We can go into a little more detail there.
Yep, thank you.
All right, man. 540-0580. John.
Hey, how you doing, Carl?
Good. What's going on?
I got a question about this PennDOT case where the plow driver hit and killed that woman. I heard on the radio yesterday that the driver has already pled to some smaller offense, and now they can't bring charges against him because of the double jeopardy rule.
Okay. So you're saying they already pled, and now somebody's died, and now they don't.
Well, the woman died. They knew that back when it happened.
That's what I mean. So you can't. You got to repeat this factual scenario for me because I'm not exactly sure I'm following it.
Okay. What happened was there was a woman traveling
right
on 322,
and the PennDOT guy turned
one of the
around.
PennDOT trucks made an illegal U-turn.
Right.
Hit her and killed her.
Right.
And that was just in October, so less than 4 months ago.
Uh-huh.
And now they're saying that the district attorney can't file any additional charges against the guy because he's already pled to something.
Well, yeah, if he's pled out already, and
how is that? That's what's got my mind boggled, because how does that happen within 4 months? You hear cases that somebody got.
He must have waived his preliminary hearing promptly. And as soon as he got up to court, pled it out.
Well, let me ask you this. Do you think it's got anything to do with the family of the victim wanting to sue the state and additional charges would?
Well, bringing additional charges is going to affect the lawsuit per se. And I'm sure the state's going to pay out the maximum of $250,000 on that claim, which is their limit.
Which is a joke. But okay.
Right. So, but no, my thought on that is you can't bring additional charges because the government's prohibited, not under double jeopardy necessarily, but under Section, I think, 110 of the Crimes Code, from bringing additional charges when somebody's pled out if the basis was known to them at the time. Now, there is case law where a guy was charged for and convicted, I believe, of aggravated assault, and then the victim died, and then they charged him with murder, and he said, that's double jeopardy, and the court said no because there was a fact available now that wasn't available at the time of the original prosecution, which is the death of the individual.
I'm just astonished at this case. But anyway, you have a good day.
All right, my friend. Yeah, I don't know the answer on that one except, they probably gave him a decent deal. It was probably just an accident, so, can't really put everybody in jail for accidents. I guess that's my personal feeling. Vivian, you're on the air. My talk line number is 540-0580. What's going on, Vivian?
I inherited stock about 50 years ago, and when the attorney settled the case, I was not in the area. He put the different stock in different ways. All of them have my first name and last name, but some have my middle initial of my middle name, some have my middle name, and some have the first initial of my maiden name. Mm-hmm. Now, here I am approaching 80. Do I have to change all of these names, or after dealing with all these years, is it understood that I am all those three people? Yeah,
it's understood you are all those three people. In fact, this comes up when we do closings for homes.
Yes.
We'll get an affidavit sheet where a name affidavit alias sheet where it says all the different ways that we can find your name out there, or you've used your name in the past. And as a result, you'll sign and say, yes, I am actually all those people. But for state purposes, yeah, the court's just going to look for reasonable proof that you're the person. And as long as the name variations are clearly yours, it shouldn't be a problem. In other words, there'll be plenty of proof that those things belong to you.
Should I see an attorney and have this prepared in advance that I am all of these three people?
Well, we certainly could do that and say that, over your years you've used these various names and have you sign a name affidavit. I guess it could come in handy if somebody wanted to be a stickler about it. Mm-hmm. So it's probably not a bad theory to have one. It might be a time also when you see the attorney just to go over your general estate plan and make sure, while you're there, get the oil change, so to speak, and make sure everything makes sense.
All right. Thank you very much.
All right, Vivian.
Thank you. Bye.
Bye. Carmen and Gary, you guys hold on a minute when we get back from break. I'll talk to you guys about child support and restaurant sale of a restaurant. 540-0580. See you in a minute. All right, we're getting some theories on the Facebook picture people are posting on there. So if you don't follow me on Facebook, I have to put this exclusive content up to lure you in. So if you want to see our substance, go to Facebook. Just type in Carl with a K, Rominger, Rominger, and you can take a look at the picture and play the game here. And at some point, if somebody gets it right, I'll tell you what it is. Or maybe somebody already has it right. Maybe we just don't want to admit what it is. That's the other possibility. 540-0580. Carmen, you're on the air.
Hmm?
Carmen, it's you.
Oh, okay. Yeah, hello, Carl. This is in regard to the guy that called about the child support.
Yes.
Was my experience that because the child is 18 years old, you stop child support.
Right.
The child is studying. The parent is obligated to help him with that. So if the child comes back to the court, or his mother, or whoever is, taking care of him, and make a petition about that, the parent is obligated to continue child support.
Now, in Pennsylvania, I know that I know that the duty to support ends when the child's emancipated from high school, or reaches the age of 18, whichever happens later. Right. But we don't have to pay for college in Pennsylvania, which is, I guess, a good thing or a bad thing. But the theory is that we don't make intact families pay for college, and we don't allow the children of intact families to get support from their parents for college by law. So it's an equal protection argument on both sides of that fence.
Yeah, but when you apply for college, when the child applies for college, they ask you about the parent's contribution.
Oh, yeah.
And there is when he can go to court and,
yeah, but there's no enforceable right to child support for college in Pennsylvania. Many other states there is. And so I'm wondering.
It happened to me because my son, I'm here, and my son, his father was in Puerto Rico.
Right.
So, the court make him.
In Puerto Rico, yeah.
Yeah.
Yeah, and Pennsylvania is one of the states that, like I say, it's important distinction. Pennsylvania is one of the states that doesn't require that, but it's not in the majority, I believe.
Okay.
All right, Carmen.
Okay, thanks.
Thank you. 540-0580. Yeah, Carmen's basically saying, somebody forced dad to pay for child support, and she's absolutely right that in a lot of states you have to support the child through college. Interesting, other states charge interest on child support, back child support. Pennsylvania does not. So it's like borrowing free money if you just don't pay if you're a deadbeat. Gary.
Yes, I was wondering. My wife and I own a property, a business property, restaurant, and that. The business is actually in her name because of health reasons and stuff like that. Let's say my name's first on the deed and everything as far as the property goes.
Right.
And I would like to go ahead and put it up for sale. What rights do I have or do I need to get to override the spouse so that I can get rid of the property?
Okay. So I just got to get this straight in my head here. You're saying that the two of you are on the deed together for the property?
Correct.
Okay. So and you're thinking she's going to cooperate or not cooperate?
Most likely not cooperate.
Yeah. So we're in some kind of what we call divorce style situation.
Yeah.
Yeah. The short answer is you would have to go through the divorce courts to get a court order because it's going to be considered presumptively marital property. That makes sense?
Well, yeah, but you don't want to get a divorce or anything like that. It's just a disagreement.
Yeah. Well, if the two, and then the answer there is I guess the two of you could sue each other, but usually for married people, when we sue over property, it's in divorce court. I'm not sure. I don't know if I'm aware of, but I think I guess you could argue that you have a contract between the two of you and just go through the regular court proceedings as if you were an unmarried couple.
Right.
But then you would be talking about a partition action to sell the land or to force one of the parties to buy out the other one's interest, etc.
Right.
So Yeah, but I would never use that. I would always use the divorce power because it's much more streamlined, although it puts everything at play. But honestly, to Pete, I mean, if she showed up in my office and said, hey, my husband sued me in partition and contract, I'd be like, well, fine, let's just sue him in divorce and we'll just, put everything back in the mix. So again, it just seems like divorce is the best way to go for a person in a married situation, is trying to devolve the property like that.
All right.
All right?
Good enough, thanks.
All right, brother. 540-0580. Tim, you're on the air.
Yeah, I'm just sort of curious. What's your opinion on the decision that was given yesterday in Georgia on the eligibility of Barack Obama?
Have I seen this?
No, probably not, because the media has totally blacked it out, but that's not surprising.
Well, let's see. Let's Google here. Tell me what's going on.
Well, what's shocking is that you don't even know about it. That's what's really shocking, that they can actually cover it up this much. There was actually a hearing that could have been earth-shaking that would have sort of created a domino effect of whether he's eligible or not. There was 3 cases. 2 were about whether he's a natural-born citizen. The third went on about the birth certificate. It went to, they tried to quash the subpoena.
Right.
The judge, for the first time in 3 years, said, no, we're going to actually hear evidence.
Right.
So they actually went to a hearing, and Barack Obama's his attorney was a Jablonski, refused to show up, sent a letter to the Secretary of State saying that him and his client weren't going to show up. They had the hearing. There was supposed to be a default. The judge offered them a default.
Right, right.
No, they said, no, we're not going to take the default. We want to put the facts on record. They go ahead, and the judge speedily said that we'll do a speed hearing. So they had a speed hearing. So they put out the facts. It was unrefuted by Obama's lawyer, obviously, because they didn't even show up.
Right.
They come to court. And he sat on it for about 3 days, and just yesterday he ruled that he is eligible to be on the ballot.
Right.
Which is disturbing to me because there was no finding of fact. I mean, the defendants didn't put up anything.
Right.
I mean, I don't get it. I don't get to where our judicial system is going today, where you don't even have to, you can thumb your nose at the judiciary and get away with it.
Well, the judge said, I think, I'm supposed to pull the opinion, he said none of the testifying witnesses provided persuasive testimony.
Right, but here's the point: is his opinion is that the only reason he dismissed their testimony was because they were not sworn in as expert witnesses.
Right,
so he stuck his fingers in his ears.
But let me ask this. No, wait. A witness has to be sworn in as an expert. So who was the lawyer doing this that didn't qualify the person as an expert before they had him testify?
A bad one.
And that's the problem.
Right. Well, that's the point. But the judge at any time could have said to the witness, at what point, why are you testifying? What credibility do you have? He could at any point done that. He gave himself an out.
Well, of course he did. Why not?
Of course he did. Why did he, Carl?
Because it's not his job to decide a decision unless it's squarely put in front of him. And they also violated the number one cardinal rule of being a lawyer. If the judge offers you a way to win, but you want to win a certain way, right? Which is turning down the default, you're an idiot. Because
no. Because at least this gives them an appeal route. At least they put it on record that was never put on record about his Social Security number, about all the PDF he put out. I want to know, Carl, how does a defendant win that doesn't even show up? Okay?
Well, he wins when the plaintiff doesn't sustain their case. Trust me, I do this all the time, and I go to court and show up on behalf of somebody.
Wait a minute.
And they're not there. The plaintiff's not there.
Okay. What's your opinion on a natural-born citizen, though? Because this judge had his own opinion that went to an Indiana case from 2009, totally dismissed Minor versus Halberstadt, totally dismissed Vodal, everything about what was in the Constitution. Now, constitutionally, what do you think is a natural-born citizen? Do you think they just said natural-born out of the goodness of their heart?
No. And if the plain language isn't clear, then you're going to have to do some interpretation, which is going to probably require some historical reading.
Right. So whose job is that? Is that the Supreme Court or a court in Indiana?
Well, and that's an interesting question, and the answer is it's every court's job to decide who they want to base it on. And I understand what you're saying is this guy based it on the Indiana courts, but you can find another jurisdiction persuasive and borrow their logic, which he did.
Okay. Well, let me ask you a question. Do you think you should have a president of the United States that is in a great territory, whether he is a legitimate president of the United States, being decided by a court, an opinion of a court in 2009, and it should not go to the Supreme Court? We're going to elect a president again that we have no idea what the Constitution said. My problem is we're in a post-constitutional country,
right?
Where we have a judiciary that'll look right at it and will do backflips, turn themselves into pretzels to get away from the issue. Okay, we are being extorted by these people. It's plain extortion. They're threatening, that there'll be violence. That if this gets overturned, if there's going to be problems in the streets. Well, are we a constitutional republic or not?
The answer is I don't know, because it depends on what the findings of fact.
Know.
No, I'm saying it depends on what the findings of fact were and whether they applied the law. And I guess the court said, I just finished this opinion, the court said, for purposes of this analysis, the court considered that President Barack Obama was born in the United States.
Bingo. What did you just say? Considered? He considered. He thought about it. He didn't find. He didn't prove it to be fact. There was nothing that was submitted by the defense as a definitive birth certificate, like me or you would have to walk in a genuine birth certificate. He considered.
Well, yeah,
tell me that's not an out.
Well, let me put it to you this way. We start with the presumption that he's a natural-born citizen if he says he is, right? But he didn't show up, so that's.
No, I'm not starting with that presumption. He's shown me nothing.
Well,
he has shown me nothing.
How do you prove anybody's from anywhere? I mean, listen, your parents could have faked your birth certificate and filed it at the hospital. I mean, it would be a giant fraud that goes all through history.
I'm not the president of the United States, okay? I had to show my birth certificate when I signed up for midget football.
Now, let me go one step farther, though. Let's assume for a minute he's not a natural-born citizen, right? There's some flaw in whether he was a citizen or not.
Well, what do you mean?
I'm just saying. Let's assume for 1 second he's not, right?
His dad.
What's the difference? What's he doing? I thought he surged in Afghanistan. I mean, he spent a heck of a lot of money and did what any other Democratic president would do.
You follow the Constitution, Carl, or you do not. It's either or. It's in black and white.
Well, you're right, there used to be
lawyers can make it gray.
There used to be parts of the Constitution that said things like, they used to have all kinds of things, and they didn't let women vote, and they didn't count.
Matter. Once you start eroding the very essence, we are a country of laws, not men. Once you start this, it will never stop.
Well, let's go through the list, and we'll do this another day, but we can go through the list of laws that I always like to whale out when I do the Durgan show that are on the books that nobody still enforces, including one that I think requires you to beat your wife under certain circumstances.
Doesn't matter, Carl. This guy has my life and my kid's life in his hands being the President of the United States.
I understand the strong feelings you have.
The Constitution was supposed to say what it says. When you start wiggling out of that, when you start playing games with it, you are in dangerous
Yeah, well, but that's fine. So the founders should have defined reasonable, right, when they did the Fourth Amendment, because nobody knows what the definition of reasonable search and seizure is. They didn't define it.
No.
There's no definition. My point is the Constitution's always open.
A Supreme Court divided in Miners versus Halberstadt what native-born citizen of two parents met. You have a judge in Georgia that totally ignores that.
Right, but
totally ignores that. And goes to a court in Indiana of 2009.
Well, he went to go to court. He found their logic persuasive, which he's entitled to do.
Well, you know what? It's not following the Constitution.
I don't know, Tim. That's the problem. At the end of the day, the court decides if it's following the Constitution, and if the United States Supreme Court wants to take this up and reinterpret it, that would be great.
Well, what's happening is our judiciary is becoming a fraud.
All right, I got to go to break. I got the message. I got your feeling. I gave you a lot of time here.
Yes. Oh, well, you should, because it's about time somebody told it like it was.
All right. Tim, listen, and I think people should definitely look at the opinion because it's interesting. But again, big lesson. I got to go to break, but let's forget about the constitutional dimensions for a second. Let's forget about the constitutional dimensions for a second and remember this. At the end of the day, if you're ever in court and you have a chance to win, but you want to win it a special way, or you want to win it by being vindicated or having some magic words cast about, don't do it, because you might not win then. See you after the break. Welcome back. Carl Rominger here answering your legal questions, 540-0580. Oh, let's see. You want to get the free will kit, you go to weekendappointment.com, download the free will kit and take that will, fill it out, send it in. You meet with a real live lawyer. Otherwise, join me on Facebook. It's facebook.com/Carl.Rominger. That's Carl with a K. And you can take a look at our picture up there and see what we think R.J. Harris may have left behind in the studios here. We've got a team of people working to identify it right now, and we're going to probably have an answer shortly. But take a look and tell us what you think. 540-0580. Sarah, you're on the air. Hello, Sarah.
Hi.
What's going on?
Hey, I have a check here that came from a friend of my son's. Now, my son owed me this money, so what he did, he just took and he signed his name to it, and then I signed my name to it, and it went to this fellow's bank. Now, he said that it went there probably about 3 times, and he still didn't have the money in there. I want to know, would my son be liable for this?
Well, I mean, he paid you with a bad check, right?
Yes.
But it's really, that's what happens when you take these things from somebody signed over. Mm-hmm. So your son still owes you the money, but you also have a right of recourse against the writer of the check as well. Make sense? In other words, he hasn't paid his debt because the funds he gave you turned out not to be good. At the same time, it's a bearer instrument, and you have a right to have it honored by the by the originator of it.
Okay. Now, the bank sent me this check. It's original check, and I could take this probably to his bank. Can I do that? Just take it to his bank before I bring legal action against this guy?
Theoretically, yes. Some of these banks are very squirrely about cashing checks these days, but theoretically, yes.
Well, the check was wrote from his bank.
No, I know. And you trust me, a lot of these banks try to give you all this rigmarole. Well, you're not a customer here, and we need your thumbprint and a footprint, and we have to hold the funds for 32 days, so you have to open an account. It's all, I don't think any of it's right when they claim all that, but the answer is you still got to get the check cashed, right? So I would try it. Can't hurt.
Okay.
And then tell your son next time to cash a check himself and then bring you the cash.
I know. Well, he trusted this guy.
Right.
And so he never did it to him before.
How much money are we talking about here? $10, $1,000?
$400.
$400, yeah. So that's a lot of money.
Yes.
Go get it.
Okay.
All right, Sarah.
All right. Thank you.
540-0580. Don, you're on the air.
Hi. Hey, I have a question in terms of living wills and also irrevocable trusts.
Yeah.
Okay, when the person dies, which one takes precedent? The will, which was actually written first, or the irrevocable trust, which came second?
Oh, the will doesn't control anything because a will only takes effect on your death.
Right, so the person's dead.
Right, and the irrevocable trust came after the will?
Yes.
But it was written after the will was written.
Right.
Yeah. So as long as the person was still alive when the irrevocable trust was created, in other words, the will has no effect on your estate whatsoever while you're alive.
Right.
So if I put $1 million to you in my will, and then I leave my $1 million to you in that will, but before I die, I put it in an irrevocable trust to Shane over here, he gets to keep it because the will's got mean spit until I'm dead. So I can do whatever I want with my assets in the meantime.
So in other words, if I understand you correctly, if you have an irrevocable trust, there's actually no need for a will.
Well, if you have a true irrevocable trust, the answer is no. There's probably not a need for a will theoretically. However, you'd still want a will for residuary purposes in case the trust gets busted somehow, someday, some way.
Okay.
And also, I got to imagine that nobody's going to put 100% of everything they have in an irrevocable trust, because if the irrevocable trust gives you wide latitude and access to it, then it's not even, there's no point of even putting it in an irrevocable trust except to avoid writing a will, and there's still going to be some tax consequences to the trust most likely. So.
Okay, well now that brings up another question, because you're saying it can be put into the trust And in this case, everything, lock, stock, and barrel, was put into the trust. And then the person died. Now, what are the tax consequences from what's in the trust? Is there a time limit? In other words, there was property put into this. There were investments.
Yeah.
And so all of this is put in here, and unfortunately, it was twisted so that from the will where it was being divided up, the person went and had a third party here, had the original person write the trust so that they got everything.
Yeah, well, and there may be an issue with the trust being fraudulently created by somebody or help using a confidential and close relationship to create this ability to sidestep the will.
Okay. Well, now, once the stuff is in this trust, is there a time period for when taxes are that you have to pay inheritance taxes?
Well, inheritance tax, that's an interesting question. It depends what the trust does with the things, because there's not going to be an inheritance tax on a trust transfer. So there might be capital gains tax, there might be all kinds of other tax implications. That's what I'm saying. Creating a trust is not a simple device to simply sidestep a probate necessarily. You could actually put yourself in worse shape.
So, in other words, the property, this person already went and took the property out of the trust and put it into their name.
Which, how could they do that unless they're the trustee and the trust allows for that? But then,
they are the trustee.
Right. So they must have made themselves the beneficiary of the trust, but there's going to be some tax consequences to that. Although I just need to map all that out on paper. I mean, literally, I don't have enough information. I need to see the trust document. I need to know all the relationships of the parties, the timing of everything. But like I'm saying, what you're saying is somebody basically, got Grandpa to write a trust, and Grandpa didn't realize that he was writing the rest of the family out. It wouldn't be the first time I saw that. And you might be able to challenge it. It's going to depend a lot on his competency at the time he did these.
That was my next question. When the trust was written, and again, this third party has all of the paperwork because he was deemed, and I don't know if the word was competent or capable of living by themselves, and so they were put into a nursing home, and then a few years after they were in the nursing home, that's when this trust was created.
Right, so we one of the things we would do is look at the doctor's notes and nurse's notes from that time period, maybe talk to people who watched that person or took care of them to find out what level of competency. And then if it's truly a complicated trust document, there might have been a lawyer who wrote it.
There was.
Curious to see what their opinion was as well.
Well, they're on the side of the...
Well, I know. And I guess that's going to be the answer. So a better question would be then to go to medical evidence. But the state of the law right now in Pennsylvania is that a lawyer's determination potentially can trump the medical evidence because of these lucid moments and things like that the law recognizes.
But there are capital gain and other tax consequences.
There's potential tax consequences. But again, that's usually something I would refer to my good friend, the CPA.
Okay.
Because we lawyers don't know nothing about taxes. That's the province of the CPA.
I understand that. What about...
We're out of time, brother. I got to go to break here.
All right, thanks.
All right, Don. Don wants like a 4-hour consultation. But hey, Don, I thought I'd give you a lot of time. 540-0580. See you after the break. All right, what do we got here? Lots of people calling in with their legal questions. That's what we have. 540-0580. Carl Rominger answering him here on WHP 580. Dave, what's going on?
Hi, I just had some questions about school funding and maybe the legal aspects of it. I don't quite understand some of it. You may, if you said you've been on the Durgan show, maybe you've addressed some of this already. But I guess one of the things that I don't quite understand is one of the governor's pushes is going to be more the charter school funding for low-performing schools. And I don't quite understand legally how that can work because, if they're taking the money away from the public schools because they're underperforming and they're giving them to another school, but the other schools don't have to meet the same requirements. They don't even have to admit everybody. And I just don't see how it just legally doesn't seem right.
This whole voucher system, right or wrong, creates all kinds of complications. But here's my real feeling on this whole issue. If you want to have the market forces, we need market forces to make schools better. Well, if you're going to have true market forces, then you have to have the ability for the schools to fail, literally. And there's a reason why we have a problem with that. There are sometimes things that if they fail won't service people's essential needs, and the infrastructure won't be there. And so what do? You have to go home and tell your kid, hey, I know you always want to go to the junior prom, but here's what happened. Your school wasn't very good. We didn't run at a profit, so they closed them down, and it's going to be a year or two until somebody probably buys up the school and puts a new one in. So you can start school back up again in 18 months, maybe when the new company comes in and relocates here to Harrisburg to open back up a school. And the point is, true competition requires true failure. And so you'll never create true competition, and there's this whole misnomer that these vouchers are somehow going to create a more wonderful school system, when all they do is allow people in the worst of the worst to pull their kids out and make the worst of the worst worse for the rest of the kids that are stuck there. So I just don't see it as a wonderful way that everybody thinks it's going to be and create this dynamic market revitalization of schools, because schools simply can't fail. They can't just pick up and relocate. And we know for a fact that when industries fail, there are sometimes time periods where critical infrastructure or supply chains and things are disrupted, and we can't have that in education. So just like bridges across rivers, these things are best left to public works sometimes. What I would suggest, and some people might disagree with me, would be to get rid of some of the power of the teachers' union, perhaps, and get rid of tenure and patronage and all those sorts of things, and just make it a competition amongst the teachers for success rather than the school districts for students. But what do I know?
I guess from that aspect, though, in other industries, if a restaurant, a person misbehaves in a restaurant, and you can kick them out. It is, because of the laws, it is almost impossible to, get rid of a disruptive student.
Well, right, and that you're absolutely right. And of course, when we talk about educational budgets, everybody goes, well, our school educates kids at an average of $7,400 per student, right? But the reality is, if you were to layer off all the special needs funding that their school districts are required to do, that average per student could fall quite a bit. Now, am I advocating that we don't provide for special needs students? I'm not advocating for that. The flip side is, when your economy's in the tanker and the government doesn't have unlimited funds, you have to draw the line somewhere. It's just nobody wants the line drawn next to them, particularly on one side of them. All right, my friend.
Well, thank you.
Take care. 540-0580. Carl Rominger here answering your legal questions. Bill, what's going on?
Carl, you guru. Hey, you said you got real live lawyers there. Are you the real one or the live one?
I'm alive and well, and I've got Drew Deo with me here, too. Drew, say hello to Tall Bill.
How are you, Bill? Can you hear me, Carl?
Yeah. Oh, we lost Bill.
Oh, jeez.
I bumped him off when I put you on because I don't know what I'm doing. What's going on, Drew, while we get Bill back on the air here?
Well, not much. I caught the tail end of that last call. Actually, I did a lot of research on No Child Left Behind when it first came out, as well as a lot of the changes that President Obama's made to it. And essentially, I think what that gentleman was talking about is just this idea of accountability, and there are very stringent accountability standards in No Child Left Behind. And unfortunately, sometimes that means that schools that need funding the most aren't going to get it because they're not living up to these test results that they have to live up to for the federal government. So it is kind of a catch-22.
Very interesting. Let's see. I think I got Bill back here. Bill, Tall Bill, did I drop you?
No. A bird flew between the antenna of the cell phone or something. Okay.
Good. I thought it was me. I got real live lawyer named Drew Deo here with me as well. That's what I want to let you know.
Good.
What'd you want to say?
Question on gas prices. We did away with the terrible monopolies, and we go after the price fixing. The Attorney General goes after price fixing. But every time the gas prices around here go up, every station goes up from $3.49 to $3.59 the next day. Is that price fixing or not?
Well, here's the dirty secret. I have a feeling that the real reason is they all buy their gas from the same refinery. In other words, The way these refineries are, it might be the Shell station or it might be the, whatever, fill in the blank. But you only truck the gas so far. So I think half of the problem is you're only dealing with a few refineries. In fact, we know that there's not that many refineries in America. Now they're saying some excess capacity at one point, and then there's not enough, but they take forever to build. So I suspect that's the number one reason, is all the gas is really coming from the same place. The additive packets are just different between each company.
Okay, thanks. Now,
all right.
Question. That guy was riding a bicycle, and those teenagers were going after him, and he shot one of them and killed the other one. Now, is that going to have to go to court? Or
No, the DA said he's clear now. They could still sue him civilly. Right. I got to go to break, brother. Carl Rominger here answering your legal questions. We'll be back for another hour live, 540-0580, 540-0580, joined by attorney Drew Deo. We'll be back.